Hi, everybody. Welcome. Happy Wednesday. Took me a minute there to remember which day it was. Today we're going to be talking about estate planning, the general components of an estate plan and what should be included and why. I am open to questions and I will be checking in with the chat as we go. My name is Colleen Masse. I'm one of the partners at Czepiga, Daly, Pope and Perri. We are a law firm that focuses on estate planning and elder law. We do have 5 offices around the state, really just for that focus. So, and the firm has been in practice for 25 years. So we've been around a little bit. We've seen, what happens and what goes wrong and what can go right. And so we have a little bit of experience with that. And, today I'm going to talk you through some of the basic estate planning documents. So the first document that we talk about with our clients when we're talking about estate planning is a power of attorney document. So when you ask someone about estate planning, typically the first thing they imagine is a will, last will and testament. And that is, I'd say that's the model of what estate planning is. But there are other documents that are really important as part of your plan. And I am always going to suggest that someone have a durable power of attorney in place when they come into my office. We pride ourselves on making plans for, setting up estate plans for people specific to their needs. We ask a lot of questions. We want a lot of input from our clients before we make a suggestion as to what should be in their estate plan. But I will say that it is very rare, if ever, that someone leaves without me suggesting they have a power of attorney in place. So power of attorney allows someone to make financial decisions or legal decisions for you if you are unable, but also even if you just are if you just want assistance. So during COVID, this was very clear to people, right? They would say, well, I might want someone to go to the bank for me. Even though I'm perfectly capable of going to the bank, it might not be something I want to do right now. So that would be your agent under power of attorney could do that. But also we set these up when we are well, in case we become unwell or unable to, participate in our own finances or legal decision making, because we want to make sure that we are choosing who is going to be in those roles. So this is a super important document. A durable power of attorney means that this power of attorney document continues to be in force, even if the person who drafted it, the principal in that is incapacitated. So essentially what we're saying is that if I had dementia, if I were in a coma, if I were incapacitated, if it's a durable power of attorney, then my agent can still act on my behalf. If it is a general power of attorney, then my agent is not able to act on my behalf if I'm incapacitated. The thought being that the general power of attorney is really for convenience. I can tell my agent, hey, please go to the bank for me, and they go to the bank for me. It's not, they're not able to substitute their judgment in the event that I am incapacitated. So I typically will be suggesting a durable power of attorney. We see far too often clients come in and they don't have this paperwork in place and something has gone wrong. When we don't have this in place, a family member or a friend or someone may need to go to court and petition the court, have a conservator put in place to be able to have your bills paid and things like that. It's a lot of work, it's a lot of stress. So having this document in place is super helpful and really important. In 2016, Connecticut did change its rules and its form for power of attorney. So if you have one that's older than that, typically we will be suggesting that you update it if you come to our office. This is a very important document. It's something that we really think that our clients should have in place. It allows someone to assist with banking and investment, to access safe deposit boxes, although quite frankly, you probably want to do that in a more concrete way. If you have a safe deposit box, you probably want to have your person listed on the bank's paperwork. You want to make sure they know where the keys are. safe deposit boxes we have found in our practice can be very difficult to access if someone's incapacitated. It allows someone to help assist with tax matters, safeguard assets. So it's an important document. No one plans on becoming incapacitated. No one plans on having a car accident or something like that. But we like to make sure that we have these things in place just in case. A power of attorney, an agent under a power of attorney cannot change your will. They can't make decisions on your behalf after death. We get calls like this all the time. I went to the bank to do some banking. My mother passed away, and the bank won't accept my power of attorney document anymore. That's correct. This is your agent under a power of attorney, is someone that's acting for you while you are alive. Once you have died, your agent can no longer use this form to access your accounts or to make decisions for you. Other things they can't do is change it to someone else. And they have a fiduciary duty, if they're acting on your behalf, to really be acting on your behalf. So you can't say, oh, I'm Colleen's agent, I'm going to go take her money out of the bank and go gamble. That's not acting in my best interest. That's not acting as a fiduciary. So the agent is supposed to be acting with your best interest in mind as a fiduciary. The other document that people can help, excuse me, during your life is a healthcare representative. And this is another lifetime document. So again, before the will comes into play, because the will doesn't come into play until you're gone. But the healthcare directive comes into play right now while you're here. So this allows someone to make healthcare decisions for you. Of course, if you are competent and able, you make your own healthcare decisions. If you're not any longer able to do that, then your healthcare representative can make those decisions on your behalf. Again, this is something that I feel is very empowering for my clients, because you are deciding who will make the choices for you if you're not able. You can choose someone that has similar ideas, someone that has similar values, someone that you've been able to communicate with and tell them what your goals are, what your hopes are, and how to make decisions for you. If you do not appoint someone, then a probate court may have to do that. And if you haven't directed them who you would like, they may not appoint the person that you would like to have in that job. So for these roles, I think it's very important and very empowering to be choosing for ourselves. Who's going to be able to step into our shoes if we're not able to act anymore? Who's going to be the one to make those decisions? I want to choose who's going to be able to do that. So I think it's super important to have these laid out ahead of time and to give some thought to it. Connecticut doesn't yet really have right to die legislation. It comes up very frequently, almost every year, but Connecticut hasn't done it yet. So we don't have that in our healthcare directives, but we do have language on living will, which says if I'm at the end of life with no hope of recovery, it can direct your agent as to how you would like them to make decisions for you. So you can make your preferences known in writing. It does have a section on organ donation, whether or not you would like to be an organ donor, and some specifics about that as well. And who can make decisions for you if you're not able to make those decisions anymore. So it's a very important document. And I think everyone should have one. Both of these, the power of attorney and the healthcare directives, I encouraged both of my children to execute them once they turned 18. One of my sons went on a hike. He hiked the Appalachian Trail during COVID. So he hiked from Georgia to Maine. And during that hike, I really wanted to have this in place. My biggest fear as a parent was that something would happen and he would be in a hospital and no one would talk to me. So, so this was something that he was willing to do. It was kind of a gift to me, right? To allow me to be able to rest a little easier. So I do think that everyone over 18 should have both the power of attorney and the healthcare directive in place. So what can your healthcare representative do, right? They can make healthcare decisions for you if you're not able to. They can accept or refuse treatment for you. Those are the big pieces. What can't they do? They can't make medical decisions for you if you are able to make your own, right? They don't override you. You are driving the bus, they are the co-pilot. If you are not able to drive the bus, then they can jump into the seat. But otherwise, you are in control of your own decision making. This is a frequent question we get. People will think they will confuse the healthcare representative form with a do not resuscitate form, and they are different. I want to get into that a little bit. I see, I just got noticing that someone had asked a question about the power of attorney. What do the older power of attorneys not offer that the new versions do? Well, one thing I would say is that if you walk into a bank with one of the older ones, they're going to be unfamiliar with it. So, right, even if it did nothing different, just the different look of it is going to cause problems and it's going to end up sent to the legal department. But there are some things that are new. There are a lot of new provisions, some of them about digital assets, a lot of them that we use all the time in our Medicaid planning. It does allow for successors, which our older ones did not allow for. So you can list, you know, I would like to name my husband as my agent. If he's not able, then I want my sons to be my agent. But there's a variety. You might be able to look them both up online and look at them, you know, side by side. There are a lot of changes. It's much more comprehensive than it used to be, and it does allow for the roles of succession. So, and it's modernized. Like I said, it's got some more digital issues. It's got some more Medicaid planning pieces. So it's been updated and is more in keeping with the modern power of attorneys that we see around the country. All right, so back to the DNR, the do not resuscitate versus the living will. A do not resuscitate order is something drafted or signed by your physician. So if you can imagine, you know, I think of myself, right, if I was driving home from work, if I had a do not resuscitate order, if I had a bracelet that said do not resuscitate, and I got into a car accident, and I was, my heart had stopped, and the ambulance driver was there, and they saw that I had a do not resuscitate bracelet, they would not resuscitate me, right? I'm an otherwise healthy person. That is not what I want. What I do have a living will, which says if I'm at the end of life with no hope of recovery, you can let me go. But simply being in a car accident where my heart might have stopped does not mean I have no hope of recovery and I'm in a terminal condition. So they're different in that way. So the do not resuscitate essentially says, I don't want to have resuscitation. I don't want CART, CPR, all that. And it doesn't necessarily mean that you're at the end of life with no hope of recovery. So sometimes people might have those if they're in place, if they have a terminal illness that could last many, many years, but they say, you know what, my quality of life isn't great. If something happens, please let me go. But it's something you need to discuss with a doctor. We as a law firm cannot set up a do not resuscitate order. You have to work with your physician on that. A living will we can set up, and that says if you're at the end of life with no hope of recovery, you know, you're able to list what interventions you do and do not want. So this confuses people a lot of the time. Here's a little side-by-side comparison of them, right? The DNR, excuse me, only by a doctor, only relates to, excuse me, CPR and other similar procedures. And as a directive, you or your healthcare rep provide to the physician. So this is, you know, it's a different document. It's a little bit, it's used in different situations, really. You may have both. You may certainly have a living will and a DNR. That's certainly a possibility. And I think probably most people that have a DNR also have a living will. This is another healthcare document that people may have heard of. Came out a few years ago, maybe 3 or 4 years ago, medical orders for life-sustaining treatment. It's a special form. It's on like this green paper. We can't even make copies of it in our office. And again, this is something that has to be done by your doctor. It has more specific provisions in it that you say what you want and what you don't want in your situation. So it has treatment instructions. It outlines the patient's choices as opposed to, as far as life-sustaining treatment. And it goes into effect when it's signed, regardless of the patient's capacity to make decisions. Obviously, you can change it if you don't want it anymore, but what it's used for, it's used as a guide for your medical treatment. Again, this is something you do with your doctor. It probably would take at least 15 or 20 minutes to do it with your doctor. It's meant to cause you and your doctor to sit and have some time for reflection about your wishes. So it's not something that's entered into lightly. It's on this funky green paper so that if it's in your chart, people can pull it out really easily. So this is a different document, and different states have it. I think some states have POLST. I'm trying to think what the maybe physician's order for life-sustaining treatment. So there's a few different ways that it's named in different states, but in Connecticut, this is what we have, the medical orders. And again, this is a physician document. So the MOLST document and the DNR are both documents that are worked on with the person and their physician. The healthcare representative is something that we can do in our office. So there's, some distinctions there to be made. All right, so here we go into the will, right? This is the cornerstone. This is what we imagine the picture of next to estate planning, if it were in your dictionary or encyclopedia. Why do we want to have a will? First I like to kind of do a little exercise where we think about what is going to follow the path of your will. So imagine for me, my will says everything to my husband. It says if my husband is gone before me, then everything to my 2 sons, right? Very typical kind of a will. Straightforward, nothing fancy about it. What is going to follow that path? What is going to follow that path are any assets that are in my name that do not have a joint owner and do not have a beneficiary. So in my will right now, in my estate, what would follow that says everything to my husband, everything to my son, everything to my 2 sons? I don't really have anything that's following that right now. Everything that I own at this point in my life is either jointly owned or has a beneficiary on it. So what is determined by the will? Well, that would be if I had a checking account without anyone else on it, if I owned a house and no one else is on the deed, if I had a life insurance policy and I didn't update my beneficiary, so there's no beneficiary on it. If I won the lottery the day before I passed away, that would follow my will. So we have 2 tracks, right? We have the beneficiary track. So I would call anything that has a beneficiary or joint owner. We have that track. That's going to follow those documents. And then we have anything that's in my own name that hasn't been earmarked to anyone. That's going to follow the will. So there's 2 different roads that things might travel. And the will is going to be for anything that does not have a beneficiary on it or is in my own name. So the will allows me to specify my executor. Who do I want to be in charge when I've died? To name a guardian for children that are under 18. That's a really important reason a lot of people will execute a will, is to have that guardian in place. And you can also create trusts within your will. Those are called testamentary trusts because they are in your last will and testament. So you can do a variety of different things in your will that will distribute your assets in accordance with your wishes. But again, we have to always remember that anything with a beneficiary designation is going to override the will. And we'll talk about why that's so important to keep in mind. What happens if you don't have a will? Well, if you don't have a will, the state of Connecticut has one for you, and they hope you'll like it, right? So the state of Connecticut has a list of how assets are distributed if someone dies intestate. Intestate means without a will, or it could mean without a properly executed will. And we do see this. We see that someone may have printed one off online or something like that. They didn't have it witnessed properly, or they've crossed things out, or they don't have it stored properly, so they only have a copy of it, they don't have the original. In all these kind of situations, it's possible that your estate could be treated as an intestate estate, meaning that your assets are going to be distributed in the order in which the state thinks they should be. So this may or may not be in conformity with your wishes. I mean, it's not random, right? The intestacy laws don't say everything goes to your postal carrier. They do have family, right? And that is typically what most people would do. But you are losing some control, and especially losing some control if you are concerned about guardianship for children. I have clients who are very concerned that someone who might be considered a natural guardian, a grandparent or something like that, is not the appropriate guardian for their children. So we want to be able to, again, this is what I'm talking about, that empowerment, right? With the power of attorney and the healthcare directives, we want to be empowered to make these decisions for ourselves, knowing that in the future life could change and we may not always be able to make our own decisions, or we've passed on and we can't make our own decisions. We want to be putting people in these positions of trust that we can rely on, and that are the people that we really want there. So here's a situation, a possibility that this one I think people are surprised by. So Sue and Doug, happily married for 24 years. Doug dies suddenly. He owns some assets in his own name. So what happens with those assets? I would bet that if I polled you all without showing you this slide, I would bet 80% of you would say they assumed everything would go to Susan. That is not the case. Part of the estate would potentially go to Doug's parents. If they don't have children, part of your estate could go to your parents. So it's not exactly what people would expect. So what happens is, and I thought we had a slide saying specifically what happens, but it doesn't, so I will tell you. The first $100,000 would go to Sue. After that, 75% of the assets would go to Sue, and 25% would go to Doug's parents, which is interesting. And in our field, we often will work with family members that are needing long-term care, and they may be applying for Medicaid or something like that. And if this happened in one of those families, this could potentially be disastrous, because funds might be going to parents who are in long-term care and messing up all of those plans as well. So this is a really good reason right here that we really do suggest people be able to put their own wishes in place so that they are able to be in control of what's going to happen someday if they pass. I'm looking for questions and I'm not seeing any, so just double checking up there to see if anyone has any other questions. So here's some celebrities that have also died without wills, and I just never understand this. I mean, I know they're busy, but they certainly have the ability to pay someone to get their estate plan in place. I know that's a barrier for some normal, some everyday people. But if, these people certainly have those abilities. So Prince, he died without a will, tragedy and a loss for all of us. But, no children. And what ended up ultimately happening is his estate passed to his siblings. So he had one sibling with both of his parents, he had one half sibling, but there were people coming out of the woodwork saying they were Prince's children. There was DNA testing. It was a whole thing going on. And it was because he didn't have a will. If he said, I want to leave everything to Sheila E., then that would have been that, but that's not what he did. So it became a lot of work and a lot of stress, right? And that's what, I think that's a legacy that none of us want to leave behind, is that legacy of stress. Making things as easy as we can for people is again, a gift that we can leave them. So this is the other piece that I was talking about, the beneficiary designations. And so this doesn't always come up in the definition of an estate plan either. But as I mentioned earlier, when I was thinking about myself and my own aspects, beneficiary designations are potentially a big part of your estate plan. And for some people, they're the biggest part of their estate plan. Some people have very large 401ks or IRAs or life insurance policies, and those assets are going to pass by beneficiary designation. And that may be the bulk of the assets that they have. So in my situation where I said I was leaving everything in my will to my husband, and if he's gone before me, then to my 2 children. If I have a life insurance policy that I had in place before I was ever married and had children, and at that time I said I was leaving everything to my sister, when I pass away, that life insurance policy is going to go to my sister, even though I have a will that says otherwise. The life insurance policy will go to the beneficiary listed. So when people come in to meet with us, we always make sure that they have double checked all of their beneficiary designations on their documents. And when they are setting up a plan, we will often draft new beneficiary designations for them, especially if there's something that's a little bit tricky, like funds are going to a trust or, different things like that. So the beneficiary designation is very, very important, and it's at least as important as the will, because we want to make sure that those are in place because they will override. If you do not have any beneficiary designation, then your funds will go through your will and they will follow it. So sometimes even no beneficiary designation is better than one, barring the concern that those assets would go through probate. So we'll spend a quick minute talking about what is a probatable asset. The probatable assets are those assets that are passing through my will, those assets that are in my name without a beneficiary. Those assets are going to be reported to the probate court. They are going to need approval from the probate court for distribution. The assets that are being dealt with by beneficiary designation or by joint ownership are going to go directly to the people benefiting from them. They still may need to be reported to the probate court depending on some other rules, but they're going to move a little bit more quickly and they're going to move a little bit more efficiently. So there's pros and cons to having assets go through your will or having beneficiary designations, and we always want to talk those through. I had a client a while back, and they had worked really hard to make sure that all of the assets had beneficiary designations or joint ownership. And so when the person passed, we had to report some things to the court, but the assets all went directly to either the beneficiary or the joint owner. One of the heirs had paid out of their own pocket for the funeral and for the repast after the funeral. And that typically would be reimbursed by the funds in the estate. Well, there were no funds in the estate. All of the money had gone outright through the beneficiary designations and the joint designations. So when that family member called me and said, how do I get these funds back? I said, well, you need to talk to your family and see if they'll all, send you a percentage out of what they've gotten already. And they said, no, but I've paid for this. Shouldn't somebody reimburse me? I said, if it were money in the estate, someone would reimburse you, but there is no money in the estate account to reimburse you. So there are pros and cons to having everything go by beneficiary designation and joint ownership. And we like to talk those through with our clients so they're making the best decisions. All right, I'm just going to check up here and see if we have any questions that I need to respond to. What if no spouse or kids? Well, then they would be looking the probate. So this is a question, I believe, on someone dying intestate. And it's saying if they don't have a spouse or kids, well, then it would be looking for potentially siblings, again, parents. If there's no siblings, if there's no parents, then cousins. There's a whole list that you can look up from the probate court of what the order is of distribution. Someone asked about cost, but I see that's already been responded to. We don't really talk about cost in these presentations. This is an educational presentation, so I can't really discuss fees at this time. All right, so this is about trusts, and a lot of people will come into a meeting with us and they'll tell us that they they believe they need a trust. Sometimes people in their questionnaire, they'll ask, what are your concerns? And they'll say, I need a trust. So they come in and I say, well, why? Why do you need a trust? And they'll say that some financial advisor said it, or Susie Orman, or, they heard somewhere that they need a trust, and that's why they're here. So, we do talk through the issues and why someone would need a trust. There are situations where we absolutely suggest a trust is necessary, and then there are other situations where we may not need to use that tool. So a living trust is essentially a legal entity that can be the owner of various assets, right? It could own your house, it could own your bank accounts, it could own a variety of different assets. So if you think back to what I talked about, what follows my will, right? I said anything that's in my name alone, with no beneficiary and with no joint owner. So if my house is owned by a trust, if it's owned by the Masse family trust, it is not in my name. So it is not following my will. And that is one of those options for reducing the amount of probate time and effort in the probate courts. So that's one of the reasons people will be using trusts, is to move more of their assets out of the probate court and make things a little bit quicker and easier for their loved ones who are managing their affairs. So why do we use trusts? When I'm meeting with clients, what kind of things am I thinking about when we ask questions? And I think people wonder why I'm asking a lot of the questions I am when we have a consult. So it's nice that, we have people at these seminars and things like that. And hopefully when they come in, they're not wondering why I'm asking so many prying questions. So one reason that, the light bulbs go off that you should probably have a trust is if you have real estate out of state. So if you tell me you have a house on Cape Cod, I'm most likely going to suggest that you have a trust. And the reason for that is because if you own property on Cape Cod and you die here in Connecticut, you are going to have probate estate in Connecticut and in Massachusetts. So now you have two probate estates, potentially need two probate attorneys, a Massachusetts one and a Connecticut one, and it's just going to be a lot more work for the people you leave behind. So if you have out-of-state property, typically we are going to say, let's move that into a trust. Again, because when you pass away, the house wasn't owned by you, it was owned by the trust, reduces the amount of work that's needed. Another reason is if there are people that don't get along in your family, or if you're doing anything kind of unusual. So if instead of saying I was leaving everything to my husband and then everything to my two sons, I said I'm leaving everything to my husband and then I'm leaving 90% to one of my sons and 10% to the other. I may not want to put that in my will. That may not be something I want to be public, because your will is a public document. Anyone can go at the probate court and ask to see your will when you've died. And it also makes it, when my heirs see that, it allows for more possibility of conflict. So the trust is able to keep things more private and makes it a little bit harder for family to argue about it. It makes it a little harder for family to fight any issues that are in there. So when we have something like that, a situation where the family may be getting disparate amounts, when we have a blended family where different people are getting disparate amounts, that's another reason we often will suggest a trust is important, to keep things private and to keep things moving as easily as possible. So I think of a revocable trust as a trust. It's a great tool, and it's a great tool for making things easier after you're gone. So we do like them, but we don't always recommend them to everyone that comes in. When we do draft a trust for someone, we also want to make sure that trust is funded. So if I am setting up a trust for somebody or for a couple or for compliance, what I'll also want to make sure I do is deed the house into that trust right? That's a smart thing to do to make sure the house is owned by the trust, because that's going to make things easier. And also we will make suggestions as to their assets. So I was working on this for a client today. Client sends in a list of all the accounts they have, and we try to move accounts to the trust, and we try to make the trust be as equal as possible so that each of the spouses has a trust of fairly equal value. Both the spouses are trustees of both trusts, so they both can manage all of the assets, but we're keeping both of their estates fairly similar. And we do that because it can help potentially if there are changes to the estate tax code in the future. So we do suggest on how to fund the trust, and we try to follow up with our clients to make sure they have funded the trust. If you haven't funded the trust, right, if you have a revocable living trust, or your house isn't in it and your accounts aren't in it, then when you pass away, you've gotten really very little value for that trust, because the house is still in your name, the accounts are still in your name, they're still going to be embroiled in the probate process. So in order to avoid that, in order to get the most value for the trust, we want to make sure we've moved the assets into the trust before we've died. That's an important piece. So here are some things that could happen. And I did allude to this already. You prepare your own will and you don't have the right witnesses. And this is, we see a lot, because even on NPR now, they're talking about, there's free wills online, and there are these will making software, all of that. But what people often will not pay enough attention to is how the will is executed. And if it's not executed properly, then it may not be admitted to court. So we want to make sure that the wills are executed properly, and that they have the right witnesses, and that they're signed in the right way, and all of that. So when people come into our office and they're signing a will, it's on this special paper. We sign it with a blue pen so that you can tell that it's the original and not a copy. So it's very important to have it all done properly, witnessed properly, etc. So Priscilla Presley, she had an amendment. It was all a mess. Things were misspelled. They weren't witnessed properly, and it wasn't accepted by the courts. So it ended up, again, a lot of litigation. Again, why is Priscilla Presley not having a decent documents? I don't understand. Especially because she went to the trouble of having the documents drafted. What happened? That her name isn't spelled properly, that it's not witnessed? I'm not really sure. But it's important to make sure that not only do we have our wishes drafted properly, but that things are executed properly and stored properly. So I did talk a little bit about safe deposit boxes, right? And so this is another question. What do I do with my documents once they're drafted? So most attorneys will have, everything's in the cloud now. So we do have a record of the documents that you have signed with us. We have them in our, in our database. If you needed copies of them, we can get those for you. The issue is that will, right? That will, in order to have it admitted to court, you really need that original will. If you don't have the original will, there's a process to get a copy, admitted. But the presumption the courts make when you can't find the original will is that you don't want people to, and maybe you destroyed it. So whoever is trying to present the copy has to overcome that. So we want to keep the will safe, right? That's an important piece. So we, as a law firm, do offer to hold people's wills. I think some other law firms offer that as well. We put a note in our file that says whether or not we're holding the wills. We actually will also put a note if you say, no, I don't want you to hold the will. I'll say, well, where are you going to put it? Then people say, well, I'm going to put it in, in this lockbox. I keep it in my bedroom closet. I'll write that down in my notes. I'll also write down, sometimes I've had clients give me the combination to the safe if they have things in a safe. So I have that in my notes. So even if we're not holding it, so we can be helpful to whoever's looking for it. Safe deposit boxes we have found to be very difficult to deal with. You have to get an order from the probate court to get into the safe deposit box. It's hard to get the order from the probate court because you don't have anything to show that you're the executor and that you should be getting the order of the probate court because the will is in the safe deposit box. I even had one client once that came in and she said, my husband left his will, it's in the safe deposit box. And so she went to the bank and they wouldn't let her have access, and we had to go to probate court and do all this work. And she went, finally she got access, and the person at the bank, when she did go in with all her probate paperwork, said, oh yeah, your name's on it, it's just on the back of the card. So even when her husband did the right thing and had her name on the safe deposit box, the people at the bank still didn't look at it properly, and she still had all that work. So we've advised people to be very careful about safe deposit boxes and make sure that someone knows how to get access if they need to. Flojo, we loved Flojo. She brought the glam to sprinting. Died suddenly at age 38, and her will was never located. So that's not a great situation. So we do have, you know, concerns about storing, making sure that things are held on to properly, and making sure that people know where your documents are. Let's see, there's another question here. It says, can people write their own handwritten will, assuming correct witnesses, etc.? Yeah, there's no requirement that an attorney draft your will. Be careful though, because sometimes on TV you'll see, like in a movie or something, a holographic will. That means if you write your own handwritten will and you sign it in your own hand, that it counts as a will. Connecticut doesn't allow for holographic wills. I had a client, it was one of those Glass Onion movies, I can't remember what it was called, but it happened, that's what it was in that movie. It was like a murder mystery movie. They were pretty good. And my client kept calling and saying, but I'm just going to handwrite it and sign it myself. I'm like, no, do not do what you see in the movies. That is not acceptable in Connecticut. So it does have to be witnessed. It does have to be signed by either a commissioner of the Superior Court or a notary. It has to be witnessed. It has to have, there's this language that's called the self-proving affidavit, which makes it so your witnesses don't have to go to court. If you don't have that, then your witnesses have to come to court. So, I mean, there's a lot to the execution of the document, and you want to make sure you get that right. So that's all I have for today. I am open to answering some questions. I know we're done a few minutes early, so if people have further questions, I don't see anything else in the chat. I'm happy to respond to whatever I can.
You are able to unmute yourselves now if you wanted to ask a question.
All right. Quiet group this week. Well, you do have my contact information here. If something does come up and you think of a question in the future and you want to send me a quick question, I can't answer specific questions due to I can only answer questions about your personal situation if we have a lawyer-client relationship. But if you have a general question, I can certainly answer that. If you want to send me a quick email, you know, and then we do these presentations fairly often with a variety of different groups. So if you wanted to get on our mailing list, that address is there too, and you can be added to our mailing list to find out when we have presentations on other topics. So we're always happy to see you at any of those too. All right. You want me to hang around for a little bit, or are we thinking that we're...
I think if there's no more questions, we can wrap up, and they have your information. And I will send the recording to everyone that was registered today, so you'll have that as well.
Awesome.
So thank you,
so much.
Colleen,
Thanks
for joining
everyone
us.
for your time, and thanks so much to the library for putting on the program. Super important, and we appreciate all you do for the community.
Thank you so much. Have a great day, everybody.
Have a great day, everybody.